I thought it was a joke at first. A bad prank. Maybe spam. But there it was, taped neatly to my front door in an official-looking envelope stamped with the HOA's logo, the same logo I'd paid dues to for nearly a decade without missing a single payment. Inside was a notice of violation written in stiff, corporate language, accusing me of something I'd never seen before in any rulebook, contract, or legal document: persistent negative energy affecting community harmony. The fine listed below, it was very real. $5,000, due in 14 days. I read it 3 times, expecting clarity to magically appear. It didn't. No description of behavior. No dates. No witnesses. Just vague phrases like hostile presence, emotional disruption, and failure to maintain a positive residential aura. I laughed out loud on my porch, half expecting a hidden camera to pop out of the bushes. But the laughter died quickly when I reached the final paragraph. Failure to pay may result in escalating penalties, lien placement, or further enforcement action. This wasn't a joke. This was an HOA drunk on power. I immediately checked the bylaws, every page, every amendment, every footnote. Landscaping rules? Yes. Noise complaints? Sure. Exterior paint colors? Unfortunately, yes. But nowhere did it say anything about regulating energy, vibes, moods, or feelings. I hadn't yelled at anyone, threatened anyone, or even argued recently. In fact, my biggest crime had been asking, politely, at the last HOA meeting why our dues had increased while the pool remained closed for the 3rd summer in a row. That question had been met with tight smiles and quick adjournment. The next morning, I emailed the HOA board asking for clarification. The response came shockingly fast. The HOA president herself replied, explaining that multiple residents had expressed discomfort with my demeanor, and that the board had broad authority to maintain community wellness. When I asked what specific action I'd taken to earn a $5,000 fine, she wrote back a single sentence that made my stomach drop: "Your overall attitude has been deemed disruptive." That was it. No appeal process mentioned. No warning. Just pay up, or else. That's when I realized something important. This wasn't about energy. It wasn't about harmony. It was retaliation, thinly veiled, poorly disguised, and wildly overconfident. They assumed I'd be scared, that I'd grumble, complain to friends, and eventually write the check. HOAs thrive on that assumption. But instead of paying, I printed everything: the notice, the emails, the bylaws, and made one phone call to a local attorney who had a reputation for taking on abusive associations. By the end of that call, my confusion had turned into something else entirely: determination. Because if the HOA thought they could fine someone $5,000 for a feeling, they were about to learn what happens when vague power meets very real law. And that lesson was going to happen in court. Within a week of hiring the attorney, the tone from the HOA shifted, but not in the way you'd expect. Instead of backing off, they escalated. Another envelope appeared on my door, this one thicker, heavier, and somehow more smug. Inside was an updated enforcement action, informing me that the original $5,000 fine was being upheld and that additional daily penalties of $100 would begin accruing until my negative energy issue was resolved. Still no explanation of what that meant. Still no evidence. Just more threats, dressed up as authority. My lawyer read the notice twice, leaned back in his chair, and laughed. Not a nervous laugh. A delighted one. He explained that vague rules are a legal minefield for HOAs, and enforcement without objective standards is even worse. But what really caught his attention was the lack of due process. No hearing. No vote record. No opportunity to confront accusers. The HOA had skipped every procedural safeguard they were required to follow. In their rush to punish me, they'd tripped over their own bylaws. We requested a formal hearing, as required by state law. The HOA responded by scheduling one, but stacked the deck. The board would serve as judge, jury, and executioner, and the meeting would be closed to other residents to preserve emotional safety. That phrase alone made my attorney's eyebrow twitch. When the night came, I walked into the clubhouse to find the entire board seated behind a long folding table, arms crossed, faces already hardened. No witnesses were present. No residents spoke. Just the board, glaring like they were offended by my existence. The HOA president opened by reading a statement about community morale and protecting peaceful energy. When my lawyer asked her to define negative energy in measurable terms, she couldn't. When asked how the $5,000 figure was calculated, she said it was appropriate given the severity. When pressed on which bylaw I violated, she flipped through papers, stalled, and finally said the board had interpretive authority. That was the moment it became obvious. They weren't enforcing rules. They were inventing them. When it was our turn, my attorney calmly dismantled the case. He pointed out that subjective feelings are not violations, that retaliation for speaking at meetings is illegal, and that fines must be tied to clearly written rules. The board's response was to vote, on the spot, to uphold the fine anyway. No discussion. No deliberation. Just a unanimous show of hands. The president smiled and said, "This matter is closed." She was wrong. 2 days later, my attorney filed a lawsuit. Not just to challenge the fine, but to seek damages for harassment, retaliation, and abuse of authority. That's when the HOA panicked. Emails started flying. The daily fines were suddenly paused. A board member accidentally forwarded an internal message admitting they wanted to make an example out of me so others wouldn't question fee increases. That single email was gold. By the time the court date was set, the HOA's confidence had evaporated. They hired a high-priced attorney, filed a motion to dismiss, and quietly removed the phrase negative energy from their enforcement guidelines. But it was too late. They'd already crossed the line, and the judge was about to see everything. And once that happened, there would be no spinning it. The courtroom was smaller than I expected, almost uncomfortably so. Close enough to see every twitch, every sideways glance. The HOA board sat together on one side, dressed in matching business-casual outfits like they were attending a conference instead of defending a lawsuit. Their attorneys shuffled papers nervously, whispering reminders. On our side, my lawyer sat calm, almost relaxed, flipping through a single binder labeled simply, Exhibits. When the judge entered, the room went silent, and something about her expression made it clear she had already read the filings. The HOA's attorney went first. He spoke confidently at first, describing the association's duty to maintain harmony and protect residents' well-being. He avoided the phrase negative energy as long as he could, substituting words like disruptive presence and community discomfort. But the judge stopped him mid-sentence. She asked him to point to the exact bylaw that authorized a $5,000 fine for attitude-related violations. He hesitated, flipped pages, cleared his throat, then admitted there was no such specific rule, only a general clause allowing the board to act in the community's best interest. That's when the judge leaned forward. She asked one question, slow and deliberate. So the board can fine someone any amount for any behavior it personally dislikes? The attorney tried to recover, insisting there were limits, that discretion had to be reasonable. The judge nodded, then followed up with a second question that landed like a hammer. Explain to me how a homeowner is supposed to correct negative energy. The silence that followed was heavy. No one spoke. Not the attorney. Not the board. Not even the court clerk. When it was our turn, my attorney stood and didn't waste a second. He presented the violation notice, the follow-up fines, and the email where the HOA president admitted the issue was my demeanor. Then he introduced the internal email, accidentally forwarded, where a board member wrote that they needed to make an example out of me. The judge's expression changed immediately. She asked for a copy, read it carefully, and then asked the HOA president to stand. Under oath, the president claimed the fine was not retaliatory. The judge asked if she was aware of the email. She said yes. The judge asked if she disagreed with its contents. The president hesitated, and that hesitation said everything. The judge called a brief recess. When she returned, her tone was noticeably sharper. She explained that HOA authority is not unlimited, that subjective standards invite abuse, and that retaliation against homeowners for protected speech is unlawful. She also noted that imposing massive fines without clear rules or due process raises serious constitutional concerns. The HOA attorney attempted to interrupt, but the judge raised her hand and continued, making it clear she wasn't finished. Then she delivered the line that changed the entire case: "This court does not regulate vibes." A few people in the gallery gasped. Someone stifled a laugh. The HOA board stared straight ahead. The judge ordered the fine suspended immediately and scheduled a follow-up hearing to determine whether the HOA would be liable for damages and legal fees. As she banged the gavel, she looked directly at the board and added, "You may want to reconsider how you exercise power." Walking out of the courtroom, I realized something important. This was no longer about me proving innocence. The HOA was now on trial, and the verdict was starting to write itself. The second hearing felt completely different from the first. The confidence the HOA board had once worn like armor was gone, replaced with stiff posture and nervous glances. This time, the judge wasn't interested in broad explanations or philosophical arguments about community harmony. She wanted specifics, documents, timelines, and accountability. Before the HOA's attorney could even begin, she asked for the enforcement policy that justified the fine. When he admitted it had been revised after the lawsuit was filed, the judge paused, removed her glasses, and stared at him in silence. That single moment seemed to drain the air from the room. My attorney presented evidence showing that the negative energy language had never appeared in any official rulebook prior to my fine. He demonstrated how the board had selectively enforced vague clauses only after I questioned their budget decisions at an HOA meeting. Then came the financial records. Dues had increased, but services had decreased. Maintenance contracts had been awarded without competitive bids. One vendor, responsible for community consulting, had been paid thousands of dollars to advise on resident morale. The vendor just happened to be owned by the HOA president's cousin. The judge's patience evaporated. She questioned the treasurer directly, asking how fines were calculated and where the money went. The treasurer stumbled, explaining that fines were deposited into a general account used at the board's discretion. When asked whether homeowners were notified of how those funds were spent, he admitted they were not. The judge then asked a question that visibly shook the board. "So these fines can be used for anything the board chooses, without oversight?" No one answered. The silence was answer enough. Then came the moment that broke them. The judge addressed the retaliation email again, asking whether any board member disagreed with the statement that I was being punished to send a message. One by one, they avoided eye contact. Finally, a board member quietly admitted that the language was unfortunate, but insisted it wasn't official policy. The judge responded sharply, explaining that intent matters, and written intent matters even more. She noted that the email showed motive, coordination, and misuse of authority. At that point, the HOA's attorney asked for a sidebar, then requested time to consult with his clients. The judge denied it. Instead, she announced that she was ordering a forensic audit of the HOA's finances, retroactive 3 years. Gasps echoed through the courtroom. She also ordered the immediate suspension of all discretionary fines until the audit was complete. Turning directly to the board, she warned them not to delete emails, texts, or records of any kind. "If this court discovers spoliation," she said calmly, "the consequences will be severe." By the end of the hearing, the HOA board looked less like a governing body and more like defendants waiting for a verdict. Outside the courtroom, their attorney refused to answer questions. 2 board members resigned within a week. Notices began appearing in the neighborhood about a special meeting to discuss leadership changes. Residents who had stayed silent for years suddenly started sharing their own stories, unexplained fines, threats, intimidation. What started as a ridiculous $5,000 fine had cracked something open. The HOA wasn't just exposed, it was collapsing under the weight of its own behavior. And the final ruling hadn't even come yet. The courtroom was packed for the final hearing. Word had spread quickly through the neighborhood, and for the first time, residents filled the benches behind me. Some nodded as I passed. Others whispered thank you. The HOA board sat in their usual place, but the lineup had changed. 2 former members were gone, replaced by interim appointees who looked like they'd rather be anywhere else. The forensic audit had been completed, and the thick report sat on the judge's bench like a warning. The judge wasted no time. She summarized the findings clearly and methodically. Over 3 years, the HOA had issued arbitrary fines without consistent standards, failed to document enforcement actions, and redirected penalty funds into discretionary spending with little oversight. The community consulting payments raised red flags, as did several no-bid contracts awarded to individuals connected to board members. While the court stopped short of referring the matter for criminal prosecution, The judge made it clear that the HOA had operated far outside its authority. Then came the ruling. The $5,000 fine was permanently vacated. All related penalties were declared void. The HOA was ordered to reimburse my legal fees in full, along with additional damages for harassment and retaliatory enforcement. But the judge wasn't finished. She issued a permanent injunction barring the HOA from enforcing any rule that was not clearly defined, objectively measurable, and properly adopted. Subjective standards, including anything resembling negative energy, were explicitly prohibited. The room went silent as she delivered the final blow. The judge ordered the HOA to hold new elections under court supervision and required mandatory governance training for any future board members. She also required full financial transparency, including quarterly reports made available to all homeowners. Looking directly at the remaining board members, she said, "Authority exists to serve residents, not to control them." The gavel came down hard. Case closed. Outside the courthouse, the atmosphere felt lighter, like something heavy had finally been lifted. Neighbors gathered in small groups, sharing stories, exchanging numbers, and laughing in disbelief that it had taken something called negative energy to expose years of quiet abuse. Within weeks, new leadership was elected. Dues were re-evaluated. The pool reopened. The mood of the neighborhood changed, not because it was enforced, but because it was finally fair. As for me, I never asked for this fight. But I learned something important. HOAs rely on fear, confusion, and silence. The moment one person pushes back, with facts, with records, with the law, the illusion of power starts to crack. The judge said it best: courts don't regulate vibes. They regulate conduct. And that $5,000 fine for negative energy, it ended up costing the HOA far more than money.